Yeah, good morning to everybody. We will have the morning session is scheduled from 10, so we are an academic quarter late until 1 o'clock. And we will deal with two clusters. The first one would be, and these clusters according to the report of the government. The first one would be Articles 1 and 27, self-determination and rights of minorities. We will start with an introduction by the representatives of the government of Taiwan, and then Professor Ando will lead the discussion by introducing some of the questions which might have been raised already with the list of issues, but of course might also be other questions. And then we have a free flow of discussion with you and the members of this committee. And after that we will have the second cluster in the morning relating to Articles 2, 3, 26, that is primarily the right to equality and non-discrimination, but also the right to a remedy, and in addition Articles 4 and 5. So that will be the second cluster with the same procedure. With that, I would be happy to give the floor to the government, also perhaps introducing who are the members of your delegation today, so that we know to whom we can address also specific questions. You have the floor, sir.
Thank you very much, Mr. Chairperson, dear committee. Good morning. And again, thank you all for coming to Taiwan to review our initial reports. This is a critical moment. This is a milestone in the development of human rights in Taiwan. In 1967, ROC had signed ICCPR. Even though Taiwan lost its representation in 1971 and has not been able to effectively participate in international human rights activities, people in Taiwan and the government in Taiwan are still willing to work together to promote human rights. Since the year of 2000, the government has started the process of reviewing and revising our laws and regulations to comply with ICCPR. As Taiwan is not a UN member, we can only use approaches to incorporate these international conventions into domestic law. And I would like to state that this time Taiwan takes the initiative to submit the reports. It took about a year for the government to complete the reports. We have invited the Presidential Office's Advisory Committee on Human Rights. We have invited scholars and experts in human rights to help complete these reports. So I would like to thank the Advisory Committee and the scholars and the experts and the NGOs for their contribution to the reports. And we thank the review committee for the questions that you raised. And we will continue to review the process of the development of human rights. We will publish periodic reports as well. Since Taiwan cannot formally be admitted as the state party to the ICCPR, and therefore we didn't have enough exchanges with the international community. And this fact had some adverse impact on the human rights of the 23 million people in Taiwan. But this does not waver the determination of the government to protect human rights. Now, allow me to introduce to you my delegation. These are our delegates from Council of Indigenous Peoples, and from MOEA, from the Gender Equality, from Ministry of Interior, from the Agency of Household, from the Judicial Yuan, MOJ, Labor Council, and Ministry of National Defense. In addition to these main delegates, there are many other government delegates who are also present to respond to your questions. Environmental Protection, Ministry of Foreign Affairs, Control Yuan, the Examination Yuan, Ministry of Education, and the Agency of Communication, NCC, and the Association for Mongolian and Tibetan People, and a Council of Labor Affairs, and Atomic Energy Council. Thank you very much.
I thank you very much for this introduction, and also I'm very grateful that so many representatives of different ministries, but also of the Judicial Yuan, Control Yuan, and others are present here in order to respond to our questions. And in that respect, I wish to give the floor to Professor Ando for starting with the cluster Articles 1 and 27. You have the floor.
Thank you, Mr. Chairman, and thank you for the Taiwan government to send such a high-level representative to respond or to engage in conversation with our committee. Now, I'm in charge of the first part, that is Article 1 and 27, and as well as several other articles relating to the equality as well as implementation of the covenant provisions. Now, I think you have given us a very printed version. But let me start reading the first question I have on Article 1 to 20 and 27. Yeah, please explain the current situation concerning the final disposal site for low-level radioactive waste in an aboriginal region that we have heard from some NGOs about the possible danger this disposal might cause. The hotel and in an aboriginal region, the hotel and resort development project at the Duran Bay and Shangyuan coast of Taiwan, excuse me. And the controversial development of the Luming hydropower plant along Lak Lak River. In this connection, please explain why the draft of Indigenous Land and Sea Territory Act has not been approved by the executive one. This relates to your government report, paragraph 7 and 8.
Let's ask the representative from the Council of Indigenous People to respond. I'm from the Council of Indigenous Peoples. About the draft of the Indigenous Land and Sea Territory Act, it refers to the Indigenous Peoples' Basic Law, and based on that parent law, we promote and self-government draft, and this draft of land and sea. And another draft is on biodiversity and the protection of intellectual property rights. About this land and sea draft, this draft is submitted for the review for relevant government agencies to look at, and now a consensus has not been reached, and therefore it has not been passed yet. But the Council of Indigenous Peoples will continue our efforts, and we hope this draft of land and sea can work hand in hand with the self-governance draft for the indigenous people. This Self-Governance Act for the indigenous people, again, is facing some challenges. For example, on January 31st last year, the draft was submitted to the Executive Yuan, but there are still some doubts. And the Act of Self-Governance has various forms in different countries. While Taiwan has a unique situation, that is, we cover a very small area, and yet there is a large number of tribes. There are 14 tribes in total, and many of them live together with non-indigenous people, the Han people. So when we design the Self-Governance Act for the indigenous people, we focus on the cooperation between different stakeholders, and we want the draft to one day pass the legislation procedure successfully. In this process, we collected many opinions from the NGOs, and so far, the process was not very smoothful, and we are planning to revise some provisions of this Self-Governance Act. After the revision of the draft, I believe we'll be able to win more supportive voices from the NGOs. In Taiwan, indigenous people may live in the mountains or on the plains, and our central mountains separate Taiwan into two areas. So we may use that lines to dedicate different zones. And in these different zones, we'll be able to work with the indigenous people better in that zone. That, I think, will satisfy the NGOs who have concerns about this act. Thank you.
The Ministry of Economic Affairs. I think this has to do with the Taiwan Power Company's operations there. So maybe the Thai Power Company's representative can say a few words. I speak on behalf of the state-run enterprise. Basically, according to the Act on Sites for Establishment of Low-Level Radioactive Waste Final Disposal Facility, the competent authority is actually the Atomic Energy Council, so maybe the council representative can provide legal explanations. We are actually the agency or the organization to execute the order. In July 3rd, 2012, we have already announced the candidate sites, including the Daren Township in Taidong and the Wuqiu Township in Kinmen. After the referendum result, we will perform the environmental impact evaluation. And of course, we have to take into account the referendum performed by the indigenous peoples there, and that will be interpreted by the Atomic Energy Council. So, in relation to the Luming hydropower plant, according to law, environmental impact evaluation has to be conducted. So, my company does not have the manpower to help with that, so we decided to put that on shelf for the time being. Maybe the representative from the AEC can say a few words. I speak on behalf of the Atomic Energy Council. The MOEA in July last year has announced the 2 candidate sites for low-level radioactive waste final disposal facility. According to our law, the next step is for the MOEA to conduct local referendum in the 2 sites, the 2 candidate sites in Taidong and Kinmen. And then, in accordance with the indigenous people's basic law, the MOEA and the AEC have discussed and decided that when the local referendum is to be held, as the Taidong candidate site belongs to a territory of the indigenous people, at least 50% of those participating in the referendum said yes. Then we can begin to pick the Daren Township as a possible site. So there are a few preconditions that have to be met. First of all, more than 50% of the local residents voted yes for the proposal in Daren Township before it can be chosen as the site. And more than 50% of the local residents have to take part in the referendum, and among those who voted, 50% has to say yes. That concludes my report. Any other additional remarks? That's all. Thank you.
Now, in this question, I have two additional questions. My colleagues may have other questions. Now, I think it's very important that you require consent of the people of the locality where the plant is going to be established. That's very important. But when you say more than 50%, how much more? I mean, that's, to me, nearly 40-some% are against, or they are just not opening their mouth. That is question one. The second question is, as I said, it is very important to investigate or examine or try to require the consent of the people who will be directly affected. At the same time, the issue is perhaps under Article 27 of the Covenant, which relates to Article 1. And Article 1 is self-determination. And in my experience in the Human Rights Committee, we try to distinguish the two, because when we speak about individual complaint, Article 27 may come in, but not Article 1. Article 1 is a collective, mostly essentially political rights of a group. So therefore, to be entitled to quote or invoke Article 1, you must be a bit of a political entity separate from the state, or even equivalent to the state. Now, so in that sense, my second question is, how do you grasp the relationship between Article 1 and 27? Thank you.
Who would like to respond to this question? Or perhaps I may add also on the referendum, because the site chosen is in an area where indigenous people live. Who is participating in the referendum? Is it all the residents of this area, or do the members of the indigenous peoples concerned have a special say in the referendum?
The Ministry of the Interior can respond to the question on referendum. Maybe the MOEA can respond first. Basically, we follow the Act on Sites for the establishment of low-level radioactive waste final disposal facility, which is a law enacted by the AEC. So maybe the AEC is the agency to respond. Okay, I speak on behalf of the AEC. In relation to referendum, according to the law, it is the same as the provisions in the referendum law in place. At least 50% of the local residents must take part in the referendum, and at least 50% of those who voted must say yes before the issue can be passed. So in the future, when the referendum is held, if it's a referendum held in a county, that means all those residents in the county have the right to vote. If it's held in a township, then all the township residents have the right to vote. The Ministry of the Interior, please. According to the referendum law, there are local referendum and national referendum. So on this issue, is it national or local in nature? Maybe the AEC has already had some idea. If it's deemed a national referendum, then it has to be reviewed by us, because national referendum usually has to do with the creation or changes to important policies or existing laws. However, when it comes to local referendum, it usually has to do with issues related to self-governance or local autonomy. So we have to define how we define the issue of site selection. Is it local or national? So that's all. Thank you.
I guess or I understand that this will be a local referendum only in the affected area. Can you tell us the percentage of the residents who belong to indigenous groups and those who do not? And then the other question was, would the indigenous peoples have specific rights in this referendum, or is it just all the residents decide?
好，请袁明会说明好。
Again, AEC, Atomic Energy Council, please. Oh, I'm sorry, the Council of Indigenous Peoples. I speak on behalf of the Council of Indigenous Peoples. First of all, as you said, before the approval is garnered, what is the distinction between Article 1 and Article 27? When it comes to Article 1, we do have the Self-Governance Act. Moreover, according to the Indigenous Peoples' Basic Law, we do have a provision concerning the approval from the indigenous peoples. First of all, local residents are eligible voters, and local chiefs. And these local people may set up a tribal committee with a chairperson chosen among themselves. So among the tribe, at least 50% of the members have to take part in the tribal committee. And in the tribal committee, at least 50% of those present must agree before an approval can be given. So when it comes to natural resources, utilization, when the rights of the indigenous peoples are influenced, that we do have a statute on the tribal approval that we rely as reference. For example, in Leshan facility, it is a very good example. The Ministry of National Affairs sent people to explain to the tribal committee, to the tribes, and the tribe organized a tribal committee to give their consent to the project. So that's one example. I speak on behalf of the AEC. I think the Ministry of the Interior talked about national and local referenda. According to the law, when it comes to the selection of disposal sites, the referendum is considered local, so it's going to be county-wide referendum. In Daren Township, the percentage of indigenous peoples in local residents is about 90%. 90%. Any other additional remarks? No, thank you.
First, what I have understood, both from the written information we received from NGOs representing indigenous peoples, and also yesterday from their oral intervention, was a basic complaint that the government of Taiwan seems to use the lands of indigenous peoples for their nuclear waste. This has been done in 1982, when the government deposited nuclear waste in Orchid Islands, Lanur Township, where the indigenous Tao people live. And there are, according to this information, health problems deriving from that. And now they say that the government seems to repeat the same mistake of the past by once again choosing the lands of indigenous people for permanent disposal of nuclear waste. Now, you seem to have confirmed that in Darin Township, 90% of the people living there are indigenous. So the question is, in general, why does the government again choose indigenous lands to dump its nuclear waste? So that's the general question that is on the table here. And the second one is then how, of course, that according to your information, to the indigenous people's basic law, the government shall not store hazardous materials in the indigenous people's regions without the agreement of the indigenous peoples. So in other words, even if there are residents that are not indigenous, it should not be a referendum where everybody participates, but it should be the agreement of the indigenous peoples. So that is the reason and the background for my questions and also my concerns in this respect. And I would like to have an explanation. In your opinion, is it true that nuclear waste is primarily or exclusively stored in areas where indigenous people live? And second, if so, have they been consulted according to the indigenous people's basic law? Would you like to echo?
我先请严能会先说明现在这种原因后。
Let me ask ATC and the Council of Indigenous Peoples to respond, respectively.
依照中华民国的法律，负责
Based on ROC laws,
地方设性废弃物处置的
the agency which choose the waste site is MOEA, Ministry of Economic Affairs.
经济部也成立了常
And MOEA has set up a committee for
的结果，
site selection.
去年的7月，
And
两个地方为
last July,
候选场址，
based on the decision of the committee, 2 locations were chosen as the wasteland. The first location is in Cayman County, which is not an indigenous area. But the second location, the Taiwan County, Darin Township, is an indigenous area. As to why these 2 locations were picked up by MOEA, I think the Ministry of Economic Affairs will have to respond to that. Delegates from MOEA?
继续补充说明哈，这个刚才有谈到，就是说选址小组，我们的选址小组是由机关代表，还有一些
Yes, we have a task force to select the sites.
研能会主管机关研能会所公布的一个场址的一个金质的一个标准。那这个金质标准里面有一些
And we select the sites on the list provided by AEC. The list states several requirements for proper sites. For example, it shouldn't be on geographically dangerous areas. It should be located around fault.
包括离岛，还有台湾本岛，去逐渐的慢慢去缩减，
So
到那个缩减到48个场址。
we screened many locations in Taiwan. We narrowed down the list to 48 locations. Then from these 48 locations, we pick up a few. The committee members chose these locations not because it was an indigenous area. As we can see, the first location is in Cayman County, which is not an indigenous community. But of course, local people's opinions have to be taken into consideration. So in the guideline to select waste site, it stipulates that it requires referendum to reflect public opinions. So, first of all, we need to satisfy the technicality of how we choose such a site, and secondly, we need to solicit local opinions on the selection of the sites. So we use this procedure, and we end up with the 2 sites. In response from the Council of Indigenous Peoples, the Daren Township in Taichung County is different from Lanyu. According to the selection guideline, well, the guideline was published in 2006, and this guideline is not retrospective. And now, since we have the guideline, I think in the future, when we pick up waste sites, we will follow all the requirements stipulated in the guidelines. Thank you very much for your response. I am from the NGO regarding indigenous concerns. I will ask the permission of the chairperson for me to make a very brief response. Would that be okay? I'm not a government delegate. I'm from the NGO community. Is it okay if they speak?
During the governmental review committee, NGOs would not be allowed to take the floor, but we are happy to hear you afterwards also, or during the NGO meetings.
Okay, thank you very much.
Sorry. Please.
好，根据针对这个问题，大概我们主管的部会都做一些回应。
I think I would like to summarize government response. We chose Lanyu as a waste site because at the time we didn't have a comprehensive procedure that includes referendum or guidelines. But now, since we have the new guidelines, we will follow this guideline in the future when we select waste site.
Further questions of my colleagues?
委员是不是还有其他相关问题想要提出的？这样子的话，接下来就由我
radioactive waste disposal on Orchid Island. What measures will the government take to safeguard the health and safety of the inhabitants on Orchid Island? And why hasn't the government conducted a thorough health examination on all the inhabitants of this island?
MOEA or the Department of Health? Any delegates that would like to respond? I'm from MOEA. There are 2 aspects. First of all, how we safeguard the safety of the waste site facility. Of course, we have regulations to ensure that. And secondly, we need to have a very good supervision mechanism and monitor system on the operation. The current operator is the Thai Power, but Thai Power has their regulations, but other competent authorities related to this issue also have their supervision mechanism. The AEC has set up some monitoring systems, monitors that can monitor radioactivity on the island, and the data can be seen immediately online. As to whether the residents' health deteriorates because of radioactivity, and at the very beginning, there were voices saying that we should conduct comprehensive check-up. And there was a survey many years ago saying that this facility did not have adverse impacts on people's health on the island, and the facility was actually operating better than other similar facilities in other areas. But of course, we understand that people on the island have some concerns, and we want to address their concerns. We invite people on the Lanyu Island to come to a center to examine whether there is artificial radioactivity in their bodies. And so far, we have helped more than 1,000 people from Lanyu with that inspection, and the records reflect that none of these people who have been checked suffers from artificial radioactivity from the facility.
Anything else? All right, then I give the floor to Professor Ando for other questions in relation to Articles 1 and 27.
Second question is, with respect to the construction of the disaster-ridden area, this refers to your government report paragraphs 9 and 359, that are the very last paragraph. Please explain in more detail, why the Shan tribe in the water resource land along Duhan River rebuilt their houses after they were dismantled by the government. Also, please clarify the composition and competence of the planned indigenous peoples court. Thank you.
好，第一个问题我们是先请
Council of Indigenous Peoples will respond to the first question. We have another delegate who is coming. So let's respond to the second question. The Judicial Yuan, would you respond? Good morning. As to the establishment of indigenous people's courts, well, this is stipulated in Article 30 of the Indigenous Peoples Basic Law. But should we set up a court, a tribunal? If we want to set up a court, we have to consider the accessibility of that court and the benefits this court can bring about for the people. Currently, there are more than 520,000 indigenous people in Taiwan, and they are scattered around in various areas and locations. And in the very beginning, the right to launch litigation of indigenous people is guaranteed in Article 16 in the Constitution. And at the very beginning, we didn't have complete statistics as to how many indigenous people use their right to litigate. But then after the establishment of the Indigenous Peoples Basic Law, it has become a consensus that we understand Indigenous people have their own rights. They are unique and they have special needs when it comes to courts. That's why in April 2012, the Judicial Yuan invited experts and scholars and eminent persons from various fields to come and sit down to discuss this issue. And the meeting decided that it is necessary to seriously think about whether we should quickly establish an Indigenous Peoples Court, regardless of the number of the cases brought about by Indigenous peoples. So last year we designated 9 courts, 9 district courts, including Taiwan, Taoyuan, Hsinchu, Miaoli, Nantou, Chiayi, Kaohsiung, Pingtung, Taitung, and Hualien district courts, because these areas are the areas that are with a bigger indigenous population. And we ask the Judicial People's Training Institutes to conduct special training, because judges not necessarily understand Indigenous peoples very well. That's why there were a couple of cases in Sima Kusi and Alili at which the judges indicate the fact that they had insufficient knowledge about Indigenous people's need. So we and the Council for Indigenous People organized 2 workshops, and again on the 31st of March we will conduct another workshop. All of this training and workshop are designed to help the judges to gain in-depth understanding of Indigenous people. And the Taitung County, where the indigenous people's population is larger, they take the initiative to invite law scholars to go to that area to explain related laws. So this is the background of the need to set up an indigenous people's court. I'm from LJ, and in order to protect Indigenous people's right to litigate, we designate 48 dedicated prosecutors to especially deal with the cases that are related to the cultures or the values of Indigenous people. Shall we address these first and then go back to the Council of Indigenous People, or is the delegates of the Council of Indigenous People want to respond right now? Okay, speaking of the reconstruction of the San Yin tribe, San Yin tribe is located in a very dangerous area. It faces the threats from the rivers and floods. So we subsidize the new Taipei city with more than 200 million NT dollars for relocation. And the plan states that we destroy this housing and then reconstruct. But in fact, what the government did is that we successfully relocate the tribal people, and then we destruct the housing. So it's not that we destruct their housing and then reconstruct. In fact, we relocate them fast before we destruct and then rebuild their housing in that area. That's our response. Thank you very much, Mr. Chairperson.
If I may have additional question. Why did they come back? I mean, to the dismantled area. Why they rebuilt? I mean, according to your, yeah.
That area is not a reconstruction area. In fact, we didn't reconstruct the housing in the same area. In fact, we create a new area to relocate them. We found a safer location and area to have some new housing and that have these tribal people to be relocated.
Dismantled people came back to their original place. And why? I mean, and what are you doing?
There were 30 to 40 households in the area, and after we relocate them to the new housing, indeed some of them moved back to their original land. We didn't require them to stay in the new housing. I think it's up to the new Taipei city to decide what they want to do.
A sort of dangerous place. The place where there is danger of overflood.
According to our assessments, yes, it is relatively more dangerous, but we don't see any imminent danger. It may be an area prone to flood in the future.
Any additional questions from my colleagues on this relocation issue? Please.
So I go to my third question. That has to do something with foreign immigrants. Now, considering the number and diversity, I'm referring to your paragraphs 352 to 354 of your government report, excuse me. And considering the number and diversity of foreign immigrant workers in Taiwan, please explain how their human rights are protected and remedies guaranteed if their rights are violated. There are some general explanations, but during our exchange with NGOs, some of them think their rights are not as well guaranteed as local Taiwanese. There are certain restrictions in law as well as in de facto. So that is the core of my question.
First, delegates from the Labor Affairs Council and then the Ministry of the Interior. Thank you for the question. I think basically we treat migrant workers, foreign workers, as equals to local residents. And the same goes for the law. Sometimes you may find deficiencies in the existing law. It has nothing to do with the applicability of the law. Rather, it is because sometimes the foreign workers have difficulty adjusting to the local lifestyle. As a result, they may face some problems that local residents have never encountered. So we basically want to help these foreign workers by providing them more consultation services. Even before they arrived in Taiwan, we would begin such services. So we have worked with these worker exporting countries. For example, we would provide the information about Taiwan's laws and customs before the foreign workers leave their country of origin. Even in their country, we would organize workshops disseminating handbooks. And once they arrived in Taiwan, at the international airport, we have a special service desk or station at the entry, we would provide these foreign workers about directions so that they know how to get to their destination. Moreover, at the international airport, we would provide additional information about Taiwan. Most important of all, we let them know what mechanisms there are for them to file complaints. 4 years ago, we began to provide one single window complaint mechanism. In the past, they had to file complaints with different local governments. There were many different hotlines. As a result, they had to memorize the hotline number, but now we have one hotline only. It's 1955, 1955. So basically, we would provide multi-language services on this hotline who will be able to answer complaints from the foreign workers. In the case of emergency, the worker on the hotline will contact the police right away. If it's about the labor dispute, then this issue will be transferred to local labor affairs department. In addition, as I said, in every hour we would follow to see whether there are emergencies reported on the hotline. And after such cases are reported, we would have a follow-up every other 10 days to make sure these complaints are addressed properly. In addition, we require local competent authority to visit the sites where the foreign worker works, either in the home or in different sites. For example, we would like to understand what accommodation is provided by the employer to the worker and what food is provided. Is there any problem with communication with the employer? At the same time, we have commissioned a local radio station to provide radio programs. There are as many as 23 radio programs for these foreign workers. Of course, 1955, the hotline is available for foreign workers to file complaints. We also perform random examinations and visits to these different workplaces. Again, before the foreign worker leaves Taiwan, we have another service station in the international airport, because sometimes the employer would have a dispute with the worker, and then he would use different means to force the worker to leave Taiwan. So if it's a case of contractual termination before the expiry date, then there's the verification procedure that has to be completed. So the local competent authority will have to contact the foreign worker to see if he or she has any questions about her dismissal. And if the employer and the worker did not get along and had a row, then we would work with NGO to provide shelters to help these workers before the dispute is settled. If the dispute between the worker and the employer shows that the foreign worker is not to blame for this dispute, then we would try to find him or her a different employer. If there are no such disputes or issues, then we will still perform the verification and then issue a statement for the foreign worker. However, if afterwards, the foreign worker finds out there are other issues they would like to complain about. Then, after they arrive at the international airport, we have the same service station where they can file complaints. So basically, they will be free to file complaints before boarding, leaving Taiwan. Our staff at the airport will then judge whether the foreign worker can go on and leave Taiwan while we process the case, or the foreign worker has to stay in Taiwan to deal with the dispute. Sometimes we can help take care of the matter and say send the foreign worker the payment he should have received after he has already left the country. So overall, I think we provide the same protection for foreign workers as that enjoyed by local workers. Yet sometimes the foreign workers may not be familiar with local laws and regulations. So we provide consultation services. Moreover, indeed, sometimes the domestic worker may have more problems because the unique nature of their work. Domestic workers, either foreign or local, are not subject to the protection of the Labor Standards Act. So we are right now working on a draft on protection of domestic workers applicable to local and foreign workers. Thank you.
Thank you very much for a very detailed explanation. Just two additional questions. You said multilingual. That means how do you secure that foreign workers can express their will, I mean, correctly? You need someone to translate for them. Now, the second question, this is a difficult one. Well, we've been talking about legal immigrants, but sometimes there are international mafia brokers who brought in many illegal foreign workers. And what is your policy about that? Thank you.
I'll respond to the first question. The lingual service, the multilingual service on the hotline, and if local competent authorities received complaints, we also have translators. We also provide translators at the service station at the international airports. How do we secure these translators? Some of them are marital immigrants or foreign students. Some are overseas Chinese. Of course, usually they don't have any problem with languages. Yet training is still needed because sometimes their Chinese, Mandarin Chinese, may not be so proficient. So we do provide training in this area. Moreover, we have to provide training in relation to legal matters. So every year we would provide periodic training programs for these interpreters. Yet we do recognize that sometimes it's difficult to secure interpreters who are good with their own mother tongue, Mandarin Chinese, and are familiar with all legal issues. However, we are doing our best to secure these interpreters. Secondly, yes, I was referring to legal immigrants, because my agency deals with legal immigrants. But for illegal immigrants, it has to do with the immigration agency. Maybe they can respond to your question. To follow up on what was discussed, multilingual services at the Ministry of the Interior, we have a database including more than 300 experts and marital immigrants who are fluent in these foreign languages. And we would also provide legal certificates of residence to allow them to stay in Taiwan. If, in the case of labor disputes, these foreign workers can stay in Taiwan until the dispute is resolved. As for illegal immigrants, for example, they have a tourist visa, but they come here to work, or they run away from their workplace for longer than 3 days. In these cases, usually, if they come to the competent authority to turn themselves in, we will simply send them back home. If the police officers found out these runaway workers, they would deport them. Sometimes, if they fall sick, we would ask hospitals or charity organizations to help provide medical care for these foreign workers. Very often, we would ask local hospitals to help provide medical help to these illegal immigrants.
Thank you for your replies, where you have explained quite elaborately the procedures in place, legal and otherwise, for the protection of the rights of migrant workers. I have one quick question, and then maybe I will have some more later. But my first question is, you do have a minimum wage policy here in Taiwan, am I right? Yes. Now, does that minimum wage policy apply to all migrant workers, including domestic workers? Can I have a reply to that, please?
Migrant workers are treated the same as local citizens in terms of our laws and regulations. So the Labor Standards Act apply to certain industries. And the domestic worker, if we consider it as an industry, the Labor Standards Act does not apply to domestic helpers, but regardless of their nationality. And that's why the minimum wage does not apply to domestic workers, regardless of their nationality. So if other migrant workers, if they are not domestic helpers, then they are treated the same as citizen workers in Taiwan by our labor standards law.
Again, in reference to the replies you've given on all that is being done for the protection of migrant workers, I have a further question. Are there, in your assessment, anything in the law or regulations, policy or practice that could contribute to a deprivation of labor rights? For example, the hiring system that may go through an agent. Are employers able to hire directly? And if so, what is the statistics on that? Are migrant workers coming forward to be hired directly? In relation to that, I also want to know what sort of information you're collecting on the success of all your programs and laws to protect migrant workers, the complaints mechanisms that you have. for reporting cases of abuse by employers. You've given the theory of what is there in the law, but we haven't heard anything about how it's being implemented and what is the number of cases that you have assisted so far, and in what ways. We don't have a de facto situation reply from you. And therefore, I'd like to know more about that and whether there's anything else in the law that could contribute to the vulnerability of migrant workers. For example, the prohibition. I come from Malaysia where there are similar situations. The prohibition of changing employer. Once you've been contracted under one employer, has created a lot of vulnerability for workers. So do you have such provisions that create vulnerabilities and put migrant workers in a weaker position, as well as statistics or data on the implementation of all your good laws and how many cases you've assisted so far?
Thank you. Who would like to respond?
Okay, allow me to explain. Now, on the recruitment system for migrant workers, first of all, I have to say that all the migrant workers are employed by the employers. So speaking of the current recruitment system in Taiwan, the blue-collar migrant workers, when they were still in their country of origin, they can only arrive in Taiwan after an employer in Taiwan decided to employ them. It's not done through an agency. The recruitment is not done through an agency, but the agency works in between. So if the employees have the qualification, they have the permit to recruit employees, then these employers will work through this agency to find a qualified and legal migrant worker. And there are agencies which are foreign and domestic. So the agencies in Taiwan and in foreign country work together in order to introduce migrant workers to Taiwan. But migrant workers do not necessarily have to go through the agency. And we have many employers from the manufacturing sector, and these companies have branches or subsidiaries in foreign countries, so they can find migrant workers through their foreign subsidiaries. Or these Taiwanese employers have other channels that can reach migrant workers. They can do that too, but what they do has to be legal. And about 4 years ago, we started a system called direct hiring. So we set up a service center so that even though some employers, potential employers in Taiwan, do not have connections in other countries, they can use this national direct hiring system to find migrant workers or foreign workers. And this center has been in operation for 4 years. What we have done best is the re-entry of foreign workers who had already worked in Taiwan before. This is beneficial for both parties because the employer doesn't have to find a new foreign worker. They had worked in the past already, and if that is the case, we can streamline the process. There will be no agency fees. Through our center, these foreign worker can be rehired by the same employer, but there will be some fees or costs incur and be imposed upon the employer. So we do a lot of re-entry cases. Last year, we started to work on new entry cases, and we realized that in some of these foreign labor exporting countries, they don't have a database of potential laborers to be hired by Taiwanese employers. So we are working on that. We help some foreign countries to establish a computer information system, a database. So in terms of recruitment system, that's what we have right now. I also want to add that the percentage of direct hiring is on the rise, but it is not high enough. I think if we have more migrant workers who come as new workers, then the percentage of direct hiring will be higher. Then speaking of protection, we have complaint system and supervision system, and the complaint is very convenient because any migrant worker can just call 1955, our hotline, and the local authority also has some procedures to receive the complaints. We have a control system behind this complaint. We follow up the results of this complaint. The central government provides much funding to local labor authorities. So on a yearly basis, we observe and supervise how these local authorities are doing in dealing with these complaints and decide whether they will continuously receive central funding. Speaking of complaints and statistics, indeed, this type of information is not included in the reports. Maybe I can provide the committee with that information after our meeting. But what I can recall right now is there are about 20,000 complaint cases coming through our hotline. But 80% out of these 20,000 cases are consultation cases. Because this hotline is very convenient. Sometimes the migrant workers got lost or they encounter difficulties in communicating with local Taiwanese. Then they can just call our hotline to ask our staff to provide assistance. So 80% of these cases are cases like that. They call to ask for assistance, or they call to ask to clarify their doubts on laws or regulations. About 1% of these cases needs immediate handling. But I think I can provide you with more detailed information and statistics after the meeting. Now, whether there are provisions or laws that make our migrant workers more vulnerable, in fact, Taiwan is a very small place, and we define migrant workers as guest workers. They are contract workers. Our old law did not allow migrant workers to change their employers, but now that act has been loosening. As long as there are employment controversies which are not treatable to the migrant workers, then they can change their employers. They can find another job. There are about 50,000 cases of changing jobs on a yearly basis, and 90% of these cases are quite successful. 10% of the cases are not that successful because sometimes it is the intention of the employee or the intention of the employer. But generally speaking, the successful rate of changing job is quite high. I'm from Ministry of Interior. Now, speaking of the abuse happens to migrant workers and whether we have laws to help migrant workers with, we have an Human Trafficking Act. And in 2006, we discovered 73 cases of labor abuse, and we found another. And these cases were sent and submitted to court to deal. And we have the prevention of human trafficking reports in Taiwan, and for 3 years in a row, the Department of State in the United States spoke very highly of our work on the prevention of human trafficking. Thank you.
Once again, thank you very much for your replies. It is in fact encouraging. What I hear you say is very encouraging. I just want an additional answer from you. You have more or less cited around 20,000 cases of consultations, more wanting information, which is very good. Do you, in your statistics, divide this according to sex? How many women are actually seeking assistance of this nature? And I ask this question particularly because of the situation of women domestic migrant workers, because of their work conditions where their work place of employment is the home, and they seldom have access to the outside. How do they make their complaint? They're isolated, in other words, and that adds to their vulnerability. My second question, so my first question is, have you got data disaggregated by sex on the complaints that come in? And secondly, are there any special measures that you're thinking of or you've actually put in place to reach out to domestic workers to find out what is happening to them in the confines of the home where they are working?
Thank you. Please.
I'm sorry that I do not have the clear breakdown. But based on our experience so far, but I think you're right that the domestic immigrant workers tend to have the most problems. Not to mention, 90% of these workers are female. So in that case, I believe there should be a high proportion of these consultation calls were made by women. Again, back to the domestic immigrant workers, as I said, they tend to have more problems because of their workplace. It's also more difficult for us to check out their working conditions. So why did we set up the 1955 hotline? It's really because we want to meet the needs of these domestic helpers. For factory workers, it's easier for them to call for help. But this is more difficult for domestic immigrant workers. That's why we have this 24-hour hotline, because usually they would have to use midnight or off hours to make these phone calls. In the past, we did not provide 24-hour hotline. But now we have 24-hour hotline services tailored specifically to the needs of the domestic immigrant workers. So, in addition to the means of such as hotlines, we also provide radio programs for these domestic immigrant workers. Through these programs, these workers can hear and learn a lot of information, and sometimes there are the get-together activities announced through these radio programs or organized by these radio stations. So the domestic immigrant workers can access a lot of information from these programs. But I think most important of all, the service station at the airport would be the most useful avenue for them to get information. For example, as I said, we sometimes organized workshops in the foreign country where they export workers to Taiwan. But sometimes they are not so good at organizing these workshops, or they did not hand out the handbooks we asked them to give to these workers. That's why at the point of entry to Taiwan at the airports, we would have this service station. We even play a short video clip to show them how they can file complaints if they run into any problems. However, we believe that institutional design is still the key, so there should be legal protection available to these workers. That's why we are working on the draft of the protection of domestic workers. It's right now under study and reviewed by the Executive Yuan. So this is the direction we will be working in. Thank you.
And I guess that the whole issue of migrant workers will also be very much discussed in the Committee on Economic, Social and Cultural Rights. And of course we might come back also in relation to freedom of movement, deportation, etc. So also the gender disaggregated data leads us already to our second cluster, and I would like to give the floor to Professor Ando on the second cluster, which of course focuses very much on the right to equality, non-discrimination, vulnerable groups such as LGBT people, persons with disabilities, gender discrimination, etc. But of course also some of the more general issues have been also discussed yesterday, I guess.
Yeah.
So I think, in my opinion, we should really focus on the discrimination issue now. But you have the floor to raise.
Yeah. Thank you, Mr. Chairman. Considering the time limit, I will try to be as concise as possible. Now, Article 2, 3, 4, nothing much about 5, and 26, this all deals with the issue of implementation of the covenant provisions and also equality of various categories. Now, the first question relates to Article 2, that is your initial report, paragraph 10, state that Legislative Yuan approved the enforcement law for the two covenants that has been explained, which carries the power of a domestic law. However, according to paragraph 12, while most of the covenant provisions are visible in the Taiwan ROC domestic laws, complete protection of individuals' rights under the ICCPR hasn't been possible. So therefore, I have several questions. Now, the first one is sort of rather academic, but what is the exact domestic legal status of ICCPR? Now, Constitution comes first in your domestic legal system, then legislative law. Now, if the covenant has a similar rank, was the same rank as legislative law, that means later law may prevail over covenant provisions. So perhaps you can clarify me the exact position of ICCPR provisions vis-à-vis your legal system. In that connection, I will go on to the issue of Article 3, that is, your legislative yuan approved the Enforcement Act of CEDAW, Convention against all forms of discrimination against women. But it is also stated that while the executive yuan has had gender equality complaint box set up since 2010, 3 years ago, to accept related complaints. There are no administrative dispositions, substantial punishment, and court decisions available yet on the violation of CEDAW. So perhaps you can explain how you are dealing with this issue. I try to finish all my questions first, and then you can respond. Well, foreign workers issue has been dealt with quite satisfactorily. Now, this point was raised by Mrs. Dairiam. That is, according to your table 9, this is complaint about employment discrimination. Many issues are on the basis of gender, excuse me. And perhaps that has much to do with the female workers in domestic service. But if you can give me any reasons behind, I should be grateful. Let's see. Foreign workers, okay. Only one question under Article 4. According to paragraph 73 of your state report, constitutional emergency mechanism include the martial law and the emergency decrees. On the other hand, Covenant Article 6 has some non-derogable rights, even in the case of emergency. And how are you trying to protect those non-derogable rights? Thank you.
Thank you very much. Those were quite a number of different questions. So I leave it up to you how perhaps take them up one by one. And perhaps starting with the question of which we discussed already yesterday, but I think it's not yet totally clear what is the real status of the Covenant on Civil and Political Rights in Taiwanese law, and can a subsequent law enacted by Parliament override the Covenant?
好的，这个问题呢。
The Ministry of Justice will respond. Before the implementation of the two covenants, we looked into this matter. What is the status of the two covenants in relation to the existing legal system? And our conclusion is the human rights protected by the ICCPR actually are those referred to in Chapter 2 of the Constitution. Moreover, according to the Implementation Act, we have to finish revising related laws within 2 years. And it is also mentioned in the Implementation Act that the two covenants enjoys a higher status than the general law. So it actually stuck in between the Constitution and the general law. Therefore, it is not going to happen that ordinary laws or subsequent ordinary laws will override ICCPR provisions. And this conclusion was presented to the Executive Yuan, which has announced this conclusion to all government bodies. Of course, we also presented the opinion to the Judicial Yuan. The Judicial Yuan enjoys independence in interpreting law. Based on the recent court decisions in recent years, I think this opinion is accepted by all. In response to the question about complaint box, it was established in 2010 at the Department of Gender Equality. Before this mechanism was established, we already enacted the Gender Equality Education Act, Anti-Domestic Violence Law, and Gender Equality in Employment Act. So this particular complaint box is something additional. The Department of Gender Equality was established in 2012. Since then, all the cases or complaints received via the complaint box totaled 164. And they covered a wide range of issues, including workplace discrimination, pregnancy discrimination, issues related to sexual harassment, or discrimination in education. After receiving these complaints, we would refer the complaints to different competent authorities. For example, for workplace discrimination cases, they will be referred to the Labor Affairs Council. As for the massive layoff of workers, we would also look into these cases to see if there is gender discrimination involved in these layoffs. The MOE will also be consulted to deal with the Gender Equality Education Act related cases. So in the process, we would set a specific deadline and we would follow up these cases. These competent authorities, after investigation, will report back to us, and then we will make sure that the reports are adequate, the investigation was adequately performed. Well, I think for cases involving domestic violence or other gender discrimination, competent authorities would have more experiences in responding to your question. Of course, when we signed CEDAW, after we signed CEDAW, we expect the courts to make use of the provisions in CEDAW in their decisions and adjudication. So that concludes my report. Thank you.
Please.
First of all, let me say I'm very happy to see members from the Gender Equality Unit sitting at the review of the ICCPR, because very often gender equality units are only associated with CEDAW reviews. And so I first want to express my appreciation that you are here. Secondly, my question is in relation to the implementation of all the covenants, and in particular ICCPR, which we are reviewing. Is there a formal mechanism by which your unit, the Gender Equality Unit, is consulted and has the authority and the power to give its opinion and have itself heard? or is it done on an ad hoc basis when there is some issue which seems obviously to be a women's rights issue, you're consulted? So that is my first question, because under the ICCPR there are many other rights, the right to life, the right to freedom of movement, the right to information, which may not be seen as women's rights issues. So I want to know, is there a formal mechanism where you have the standing to be able to intervene? That is my first question. And secondly, I just want to make a comment on a question that was raised in the list of issues and which you have replied, and which is to do with the interchangeable use of the expression equality and equity. And you have replied that you realize there's a difference between the two. You don't see the two as same, but that it is used interchangeably. I just want to give you a comment that as long as you see there's a difference between these two terms, I would suggest that you do not use the two terms interchangeably. Equity should be used at the right moment and equality at the right moment. The CEDAW uses equality, and the CEDAW committee does not accept that equity can be used interchangeably with equality. And so we need to, for normative standards for the equality implementation of women's rights in the ICCPR, we turn to CEDAW. The ICCPR doesn't give enough guidance on the gender equality normative standards, so we do not, I would suggest that we stop using it interchangeably. Thank you.
Thank you very much. Allow me to separate my response in two parts. First of all, speaking of the complaints mechanism, after the Department of Gender Equality was established, we had a gender equality complaint box to receive gender complaints. In the future, if there are complaints that require our handling and the cases are not covered in the Gender Equity Education Act or Acts of Gender Equality in Employment Act or the Prevention Act of Domestic Violence, some complaint cases indeed require a special approach. So we are now drafting a basic law for gender equality. We want to design a complaint mechanism in the draft and a handling procedure of the complaints so that the draft will work better with the legal framework. That's the first part of my response. And second part, speaking of gender equality and gender equity, usually we use gender equality. We seldom use gender equity. I think this is an issue of translation because the Gender Equity Education, in the Gender Equity Education Act, the word is translated into equity, but we understand it should be equality, and we may very well adopt your suggestion to change it into equality. So thank you very much for your suggestion.
Asma?
Just two questions. One is that have you considered what are the affirmative actions that the government has taken in terms of promoting gender equality, particularly in the field of promoting women in decision-making positions? And secondly, Article 17 of the ICCPR, which talks about privacy, we have seen that mainly privacy of women is not really taken as a very serious matter, though that is violated more often than anything else. So when there is, for example, a matrimony or a marriage of a woman to a woman or a woman to a man that takes place, does the woman have to write her religion? And does religion, in a way, control the marriage ties of a woman? Secondly, when there is a question of custody of children, do courts look at equality between parents and the welfare of the minor, or are the male partners given preference over women because of their readiness or their ability, so-called, to work and get more resources for the child?
Thank you for your questions. Now, in terms of the promotion of women's rights, the government has input a lot of efforts. Our first effort is the ratification of CEDAW. In 2011, we passed the implementation acts for CEDAW. So starting from last year, we started to review all the laws and regulations and administrative measures to see if they are consistent with provisions in CEDAW. We invite central government agencies and local government to come into this process and to provide their statistics on a gender basis. And when they implement their measures, we want to know if all the agencies have guaranteed gender equality. Secondly, in 2011, we established a policy guideline for gender equality. There are 7 chapters in this guideline. This guideline involves the right to participation of women, the right to family, the right to work, and the rights related to energies or the environment. So this guideline is quite comprehensive. There are 7 main aspects, and in total there are 255 measures in this guideline. All the agencies under the government need to work together to promote these measures.
We know that, but affirmative action is what we asked for. What is the affirmative action that the government has taken? Special measures. All right. You know, to give, yes, accelerate equality, to give more measures to women so that they eventually catch up, you know. Affirmative measures. I don't know whether you've got the right translation or not.
是，跟委员报告，我们这样子，我们会后再补充那个我们性别平等。
We can submit the information related to our guideline after the meeting. And now I would like to give some examples. Now, speaking of decision-making power, well, at the government level, we know that when women want to become, when women are elected, the votes that they got are usually less than the votes got by the male candidates. But our law stipulates that half of the candidates must be women, so we have a quota requirement. And for local elections, 1/4 of the candidates, or one-fourth of the candidates have to be women. And in terms of custody, if there's a divorce, who has the custody and on what grounds the custody is decided. In our Taiwanese laws, there are some advanced regulations as part of our civil code. The custody is decided on the grounds of, in our civil law, in our civil code. The custody is decided upon the willingness of the children and objective fact. So it was very old thinking to grant the custody to the father, but now we take very objective fact into consideration. So many mothers are now granted with the custody because apparently they can provide more resources for their children.
On the issue of religious freedom, after they are married, women can still exercise their religion of their choice. I'll speak on behalf of the Judicial Yuan. The Grand Justice in 1994 wrote a report on the parental and maternal rights. The old law basically gave more power to the father. For example, when it came to the discipline of the child, the father's opinion would dominate, but that has been changed. And then later, the Grand Justices interpreted a provision of the civil code as unconstitutional because it gave the husband the right to decide the domicile after a couple get married.
Just clarify the one answer on the affirmative action. You said that, I understood, at national elections, half of the candidates must be women. What does that mean in reality? Was it? I understood candidates. So you don't have a 50% women quota in parliament, I guess. But does it mean that every political party has to have a 50% quota, or I just have not really understood what.
Let's clarify.
Yeah.
不是当选一半女性哈，是
It's really about the nomination. 50% of the candidates nominated should be female. For the nomination of candidates for regions, for certain regions, there has to be 50% nominated.
By the political parties?
By party.
Yes, by political party.
But don't you have a system where you have lists? So you still can have, let's say, you nominated on your list 100 people, and the first 50 are men, and then afterwards are women. So the women have a very little chance to be elected finally, or how does that work in practice if parties have to nominate 50% women?
One person, one woman, one female, and one male. One female and one male.
Yeah. And that applies to all parties that participate in the elections, to all political parties. But that would then mean, in reality, you should have a 50% quota in parliament. So how, if you look at the legislative yuan, how many elected members are women and how many are men?
I think, first of all, let's talk about the parliamentarians, legislators. Some of them are elected through the regional elections. Anyone can become a candidate, but there is another election which is not region specific, and to become a candidate in these non-region specific elections, political parties will have to nominate their candidates. Therefore, we would have two kinds of elections for the legislative body. Therefore, there's no way we can control the results in terms of the gender proportion. As for local elections, basically the quota, there must be at least a quarter of the elected officials at the local level that are female. A quarter.
What is the real percentage of women in Parliament today?
国会目前是33%。
33.6% of the legislators are women.
May pass on to Professor Cohen.
I'd like to follow up with a request for confirmation of statistics about the role of women as legal professionals. My impression is slightly over half the law students are women. I don't know if that's correct. What is the percentage of women who become members of the bar? What is the percentage of women who become judges and prosecutors? And can you differentiate between the percentage of women at the working level of the trial court, the appellate court, on the one hand, and at the higher courts, whether the Constitutional Court or the Supreme Court or Supreme Administrative Court? In other words, are women represented adequately at the highest levels of the legal profession?
They're now looking for data in this area. Could we be allowed to provide you this data after the meeting?
We would be happy to receive this in writing after the meeting. Any other issues raised in relation to equality and non-discrimination? No, or in general in this area, please. Yes?
I have just some issues, and if you allow me, I will say them all out now so that people can think about it and